Earlier this year, the Senate Judiciary Committee reported a bipartisan bill to protect the independence of the special counsel, Bob Mueller. Several Republican senators who are here today cited Scalia's dissent to justify their opposition to a bill protecting the special counsel, with one even saying, and I quote, "Many of us think we are bound by Scalia's dissent." At the time, I joked and said, instead of dealing with stare decisis, we're dealing with Scalia decisis. Given your views on Morrison versus Olson, we are obviously worried that you will feel bound by this dissent by Anton Scalia if President Trump decides to attempt to fire the special counsel, Bob Mueller. It doesn't stop there. You cited Scalia's dissent in the case involving the Consumer Financial Protection Bureau, where you gutted that agency. And in the 2011 Seven Sky case, you dissented from a decision upholding the Affordable Care Act and made a breathtaking claim of presidential power, which has been repeated over and over again. And you said, under the Constitution, the president may decline to enforce a statute that regulates private individuals when the president deems the statute unconstitutional, even if a court has held or would hold the statute constitutional. Your words. Of course, the unitary executive theory was the basis for President Bush's December 30th, 2005 signing statement claiming the authority to override the McCain torture amendment. Yesterday, I asked you what comments you made on the signing statement as President Bush's staff secretary. Senator Feinstein asked a similar question this morning. What you told me was, I can't recall what I said. I do recall there was a good deal of internal debate about that signing statement, as you can imagine. I do remember it would be controversial internally. It's hard to imagine you can't remember that controversial issue. Given our concerns about your views on executive power, it's important for you at this moment, please, to clarify for us the power of the presidency in this age of Donald Trump.
Senator, thank you. First, thank you for your comments about my wife and daughters. My daughters will return this afternoon for return engagements, so they'll experience democracy once again in action, and I appreciate that. On Morrison versus Olson, a couple things at the outset. First, that case did not involve the special counsel system. I have written repeatedly that the traditional special counsel system, which we have now and have had historically, is a distinct system appointed by the Attorney General. Morrison has nothing to do with that. That dealt with the old independent counsel statute, as you said, which has expired in 1999 under overwhelming consensus that that statute was inappropriate, unrestrained, unaccountable, as you said. Secondly, Morrison, Justice Scalia's dissent, that does not affect the precedent of Humphrey's executor. Humphrey's executor is the Supreme Court precedent that allows independent agencies to exist. Those independent regulatory agencies continue to exist, of course. So both on the independent agency side, those are unaffected. On the special counsel side, that's unaffected. You mentioned the CFPB case. My decision in that case would have allowed that agency to continue operating and performing its important functions for American consumers. The only correction would have been in the structure, because it was a novel structure that was unlike every other independent agency that had been created previously. As to the concept of prosecutorial discretion that's referred to in the 2011 case, that is a traditional concept, prosecutorial discretion, that's recognized in the executive branch. The limits of it are uncertain. That's arisen in the immigration context with President Obama. There's debates about what the limits are. Those are not finally determined, but the basic concept of prosecutorial discretion is all I was referring to there. I've made clear in my writings that a court order that requires a president to do something or prohibits a president from doing something under the Constitution or laws of the United States is the final word in our system, our separation of powers system. That's Cooper versus Aaron. That's Marbury versus Madison. That's United States versus Richard Nixon. That is an important principle. And finally, I would say that the question of who controls the executive power within the executive branch, the vertical question. You have the president at the top, you have independent agencies which exist consistent with precedent, is distinct from the question of what's the scope of the executive power vis-a-vis Congress. On that latter question, the scope of executive power vis-a-vis Congress, I've made clear in the context of national security, the Youngstown framework, context of administrative law, my cases questioning unilateral executive rewriting of the law, in the criminal law, where I've reversed convictions, that I am one not afraid at all through my record of 12 years to invalidate executive power when it violates the law.
Let me ask you this, because you've referred to Judge Youngstown case in the context of a war and a decision by a president that was immensely unpopular.
Yes.
And the decision, or might have been popular, I should say, and the decision of the Supreme Court, which could have been very unpopular at that moment in history. What I'm trying to ask you is an historic context. Do you understand where we are as a nation now? When books are being written about how democracy dies, when fear of authoritarian rule and the expansion of the executive branch is rampant in this country, when illustrations of it are found around the world, why we are asking you over and over again, give us some reassurance about your commitment to the democratic institutions of this country in the face of a president who seems prepared to cast them aside, whether it's voter suppression, the role of the media. Case after case, we hear this president willing to walk away from the rule of law in this country. That's the historic context which this is in. Not a particular case, but a particular moment in history.
Senator, my 12-year record shows, and my statements to the committee show, and all my teaching and articles show my commitment to the independence of the judiciary as the crown jewel of our constitutional republic, my citing of Justice Kennedy, for whom I worked, who left us a legacy of liberty, but also a legacy of adherence to the rule of law in the United States of America. No one's above the law in the United States. That's a foundational principle that I've talked about, coming from Federalist 69, coming from the structure of the Constitution. We're all equal before the law in the United States of America. And I've made clear my deep faith in the judiciary. The judiciary has been the final guarantor of the rule of law. As I said in my opening, the Supreme Court is the last line of defense for the separation of powers and for the rights and liberties guaranteed by the Constitution and laws of the United States.
You see, that's why the unitary theory of the executive is so worrisome. What you have said is what I want to hear from a co-equal and very important branch of our government. But what you have said in relation to Morrison suggests the president has the last word.
I have not said that, Senator, and I'll reiterate something I said a minute ago, coming from Cooper versus Aaron, coming from Marbury. When a court order requires a president to do something or prohibits a president from doing something under the Constitution or laws of the United States, under our constitutional system, that is the final word.
Let me ask you one last time the question you knew I'd ask about your testimony in 2006.
Yeah.
I'm just struggling with the fact that when I asked you about this issue of detention, interrogation, and torture, you gave such a simple, declarative answer to me and said that I was not involved and am not involved in the questions about the rules governing detention of combatants. We have found at least 3 specific examples where you were. 3. Your discussions about the access to counsel for detainees, your involvement in the Hamdi and Padilla cases, and your involvement with President Bush's signing statement on the McCain torture amendment. Judge Kavanaugh, you say that words matter. You claim to be a textualist when you interpret other people's words, but you don't want to be held accountable for the plain meaning of your own words. Why is it so difficult for you to acknowledge your responsibility, your response to the question, and acknowledge that at least your answer was misleading, if not wrong?
Senator, You had a concern at the time of the 2006 hearing, which was understandable, whether I had been involved in crafting the detention policies, the interrogation policies that were so controversial, that the legal memos had been written in the Department of Justice that were very controversial. As you know, and as the committee knew then, 2 judicial nominees to the Courts of Appeals had been involved in working on some of the memos related to that program. Senator Feinstein led the Intelligence Committee investigation of that matter, produced a massive report, a large unclassified report, and apparently an even larger classified report. The Justice Department Office of Professional Responsibility produced a long report about all the lawyers who were involved. I was not involved in crafting those policies.
Do you deny being involved in the 3 specific areas involving detention and interrogation, which I've just read to you? Do you say that you had nothing to do with the Hamdan and Padilla cases, that you weren't involved in the conversation about access to counsel for detainees, that you weren't involved in President Bush's decision on the signing statement on the McCain torture amendment? Are you saying that none of those things occurred?
Senator, what I've made clear is I understood your question then, and I still understand it now, and I understood my answer then, and I still understand it now to be about those legal memos. I was not read into that program. I was not involved. My name does not appear in Senator Feinstein's report, which
That's not the question I asked. Do you deny the 3 specific instances where you were involved in questions involving detention and interrogation?
That was the question that I saw that you asked at the time of that hearing, and my answer was then and is now, as Senator Feinstein's report shows and as the professional responsibility report shows, I was not read into that program.
That is not, I didn't ask you about that program.
Okay,
I asked you
your
about
current
the 3
question,
specific instances.
the current
You
question,
keep answering, oh, I wasn't, Feinstein is my defense. She came to my rescue. She was talking about something else. I've asked you about 3 specific instances where we have written proof and sworn testimony from you now that you were involved in these 3 things, and all of them relate to detention and interrogation, which you gave me your assurance you weren't involved in.
Senator, I'm going to distinguish 2 things. One are what you were asking me in 2006, and my testimony then was accurate and was the truth. What you're asking me now is, for example, on the signing statement, as we discussed in your office, I made clear that, of course, as staff secretary, everything that went to the president for a 3-year period with a few covert exceptions would have crossed my desk on the way from the counsel's office or the policy advisor or wherever it was going, and would have made its way to the president's desk, and that includes that signing statement.
Well, let me just close. I don't think the staff secretary to the United States president is a file clerk.
Right.
What you have explained to us over and over again, this was a formative moment in your public career. You were giving constitutional issue advice as well as making substantive changes in drafts that were headed for the president's desk. And one of them involved John McCain's torture amendment. And that, to me, is involved directly on detention and interrogation. And I think, unfortunately, your answer.
Want to speak to that, then we'll go to Senator Lee.
I just wanted to close, Mr. Chairman, by thanking Senator Durbin, and in response to his questions about the judiciary, the role of the judiciary, he gave me a book when we met, biography of Frank Johnson. And that Friday night, after a lot of Senate meetings and a lot of practice sessions, I went home, read the whole thing, and I appreciate it. It's a good model of judicial independence. It's a great story about someone who was a judge in the South in the civil rights era who stood firm for the rule of law, and so a good model. And I thank Senator Durbin for giving me the book.
Well, I thank you. If I just say one word, thank you, Judge Kavanaugh. And that night, obviously, the Nationals weren't playing.
Yes.
Senator Lee.
Thank you, Mr. Chairman. Thank you again, Judge Kavanaugh, for your willingness to answer our questions. I want to follow up a little bit on this last line of questioning from Senator Durbin. Senator Durbin and I actually, notwithstanding the fact that we come from different parts of the country, have different political ideologies, come from different political parties, we share many views in common, and this is one area, in indefinite detention, where he and I are concerned about the government not overreaching. Only as I look at this, I think this cuts in your favor, not against you. Tell me if I'm missing something. In the first place, what you were asked about was whether or not you were involved in crafting the policies that would govern detention of enemy combatants. Is that right?
That's correct.
And that was a classified program, classified at a very high level, presumably compartmentalized, such that you would have had to have been read into that program in order to participate in that process. Is that right?
I believe that's correct. Read in, I wasn't necessarily using the formal sense of that, but what I meant is I was not part of that program.
Okay. But that is a binary issue. You were either involved in the development of that policy or you were not.
That's correct.
And you were not.
That's correct.
And Tim Flanagan, who was, I believe, at the time the White House counsel.
He was the deputy counsel.
The deputy counsel has confirmed that you were not involved in that.
That's correct.
We have your word and the word of the then deputy White House counsel. Then there is a separate issue. Well, I guess one could argue a related issue, but a separate.
I don't know if it's worth it, but what he says, I'm not read into it. I don't know whether people understand what that means.
I assume that won't be counted against me there.
It will be counted.
Oh, okay. All right, well, I'll have to speak more quickly then. When we talk about being read into, that is a colloquial term that we sometimes refer to. It's government speak that talks about being cleared to discuss certain classified matters. In any event, you were not brought into the development of this policy.
That's correct.
Secondly, there was a separate, arguably related, but a distinct issue involving a meeting where you were asked for your opinion about how Justice Kennedy might react to certain legal arguments that people in the administration were pushing. Is that right?
That's correct.
And you answered that question.
I said that indefinite detention of an American citizen without access to a lawyer, which at the time was what was happening in that particular case, would never fly with Justice Kennedy.
And I happen to agree with you on that, and it seems like a fairly unremarkable proposition to me. I don't think anyone disputes that that argument had problems with it, that that argument wouldn't fly with Justice Kennedy, and I therefore have difficulty seeing how this cuts against you. As someone who believes in civil liberties and who shares many of the same concerns that have been expressed by many of my Democratic colleagues, I think the advice you offered here was accurate. I think it was good advice. It certainly is not inconsistent with the statement you provided, which was that you were not involved in the development of the policy governing the program. Sometimes as lawyers, we're called upon to offer litigation strategy. Sometimes we're called upon to handle litigation. Other times as lawyers, particularly in the government, we might be called upon to develop a policy. Here, you were involved in neither handling the litigation directly nor in developing the policy. You went to a meeting, somebody asked that question, you gave them your answer.
Yeah, that's correct, and it was about something entirely separate from that policy or the legal memo.
Separate and distinct from that policy. It was about a litigating position that dealt sort of in the same universe, but not with that policy.
That's correct.
I therefore have grave difficulty in seeing that you did anything but the right thing and that you answered this question in any way other than with the truth, the whole truth, and nothing but the truth. Let me turn next, while we're talking about colleagues with whom I often agree and with whom I often work across the aisle. Senator Booker is a good friend of mine. He is a colleague. He and I work together on a lot of issues. He raised an issue last night that I wanted to touch on with you. he raised an issue related to some emails. I was concerned at the time that you didn't have the emails in front of you, and I think that's very important for any witness in any proceeding to be given access to the documents. Documents that in this case were prepared some 18 years ago. You as a lawyer have no doubt been involved in the creation of many hundreds of thousands, possibly millions of documents. To ask you to recall from memory something you wrote 18 years ago is going to be difficult at any moment. In any event, these emails deal with an issue involving some questions surrounding a Supreme Court case called Adirond Constructors versus Mineta. So let's refer to a document, document 002899596. As I understand it, you were being asked in this instance to provide some advice on what might happen if a particular argument were presented to the Supreme Court on the merits. You looked at some Department of Transportation contracting regulations. And as I understand it, correct me if I'm wrong, if I've understood it correctly, the government was considering making a series of arguments before the Supreme Court, and you did what a good lawyer should do when advancing an argument to the court. You counted to 5. You identified 5 Supreme Court justices who you believed would not accept the government's argument in defense of those DOT regulations. Is that right?
That's correct. Under the precedent that existed at the time, the Croson precedent, I think, was the most relevant precedent.
And so, and yet at the time, the Supreme Court of the United States had already granted review of the case, granted certiorari, meaning the Supreme Court, unlike most appellate courts, is in charge with very, very few exceptions remaining today, of its own docket. It decides which of the 10,000 or so cases that want to go to the Supreme Court each year will in fact be reviewed by the court. The court had already granted certiorari, granted in review in that case. Is that right?
That's correct, I believe.
So as I read these emails, I read your argument as saying, okay, number one, you cannot count to 5 here because I'm identifying, Brett Kavanaugh, have identified that there are grave doubts as to whether Chief Justice Rehnquist, Justice Scalia, Justice Thomas, Justice Kennedy, or Justice O'Connor can embrace these arguments in defense of these Department of Transportation regulations. But the court has already granted certiorari, so what to do? As I understand the emails, and correct me if I'm wrong, you recommended a course of action that would allow the government to make its case, but to make its case in a way that it would allow the court to decide that perhaps it shouldn't have granted review in the case. Am I correct so far?
That's correct, Senator.
And what is that called when the court decides that it shouldn't have granted a case?
Dismissing as improvidently granted, or other colloquial known as digged.
As a dig.
Yeah.
So you came up with a strategy for the purpose of encouraging the court to dig a case that it had previously granted. Because you believed the government was going to lose, and the regulations at issue were going to be invalidated. And you didn't want the government to have to endure that. Did they accept your arguments?
The Supreme Court did, yes.
So the government, the Bush administration, the Solicitor General's office, followed your advice and wrote the arguments as you had prescribed, thus prompting a dig. And as a result, the regulations stood. Isn't that right?
I believe that's so, Senator.
They stood where they otherwise would have fallen.
That's right.
Okay. So here again, I have a hard time seeing this as anything other than something that helps you not just with Republicans, but that helps you with Democrats. You saw a problem with an argument the government was making. You identified that problem. You offered a remedy. That remedy was embraced by the Solicitor General's office and the Department of Justice, and the court did exactly as you wanted it to do, and as a result, the regulation stood. The regulation that Senator Booker is concerned about, was wanting to make sure was not under attack unfairly, was in fact preserved. I have a hard time seeing why that shouldn't make him want to vote more for you. In fact, I think Senator Booker really should vote for you. I'll have that conversation with him later.
Okay.
Hi, everyone. I'm Rena 9, and you've been watching the confirmation hearing for Supreme Court nominee Brett Kavanaugh. Well, today, Democrats released previously confidential documents related to Kavanaugh's views on abortion and racial profiling. One of those was an email from 2003 from Kavanaugh, and it appears to show him questioning whether Roe v. Wade actually is settled law, and that puts him at odds with what he said earlier this week. We're going to have more on that in just a moment. But first, we begin with the president seething over the publication of a scathing anonymous op-ed in the New York Times. The author is said to be a senior official in the administration, and today the hunt is on to find out who that person is. And since the op-ed's release, several top officials or their offices have denied being its author, including the vice president, the director of national intelligence, Dan Coats, the secretaries of state, defense, housing, treasury, and homeland security, and the U.S. ambassador to the UN. Vice President Mike Pence was trending online yesterday because he said that the op-ed included a word that he's used in the past. That word, lodestar. Well, today, the vice president slammed the author and the New York Times.
Well, I think it's a disgrace. The anonymous editorial published in the New York Times represents a new low in American journalism. And I think the New York Times should be ashamed. And I think whoever wrote this anonymous editorial should also be ashamed as well.
The op-ed questions the president's fitness for office. The author writes that officials are, quote, thwarting Mr. Trump's more misguided impulses until he is out of office. Well, in response, the president called the official gutless and called for the New York Times to turn the person over to the government. Lawmakers have remained mostly silent on this explosive release. And here's what House Speaker Paul Ryan had to say when asked about it today.
A person who works in the administration serves at the pleasure of the president. It's a person who obviously is living in dishonesty. That doesn't help the president. So if you're not interested in helping the president, you shouldn't work for the president, as far as I'm concerned. Yeah.
Well, joining me now, CBS News Washington correspondent Paula Reed, who joins us from the White House. So, Paula, what's been the mood inside the White House since this op-ed was released?
I would describe it as defiant and a bit paranoid. I mean, not only is the president seething over this op-ed, he's also very upset about this book forthcoming from Bob Woodward. That book alleges that dozens of people in his own government, even in his own White House, are alleging that he is not fit to serve. I mean, this is not something that is new. There's been a lot of leaks, almost an unprecedented number of leaks from this White House, many of which are very critical of the president. But here it seems to have reached a fever pitch. But as you saw there, White House officials coming out and slamming not only the anonymous op-ed, but also the New York Times for publishing it.
You know, we know that the president has tweeted about this. Treason, calling it deep state, and also claimed that the swamp he's trying to drain is fighting back. Are there any concrete actions that the White House could take to combat this? And do you think that they could ultimately force the New York Times to reveal their source here?
I really don't think they have any ground, legally speaking, to force the New York Times to reveal the identity of this person. There are some potential legal avenues when it comes to leaks, but he really doesn't have any great options there because, first of all, he would need to argue that this fit under some sort of broad national security protection. And while the definition under the law for that is pretty broad, I think it would be difficult to make that case here. Now, the other option is to ask the Justice Department to pursue a leak investigation. But if the Justice Department was to pursue a leak investigation, you would essentially be admitting that whatever was revealed is true. Now, the White House can also pursue its own leak investigation, but really there are no good legal avenues here. It would be best, it seems, for the president to really focus on a political response, which is what he is doing, which is pointing to his supporters and say, look, this is the deep state, this is the sort of swamp that I'm trying to drain. As I drain it, they are trying to bite back. That seems to be what he's doing here. And compared to his legal options, that really seems like the best bet for damage control.
And we know yesterday the tweet came out from former White House official Omarosa saying, look at page 330 of my book. This might reveal who that source is. Does the White House internally, do you know, Paul, if they know who they believe? Do they have somebody they believe is behind this?
There's one source who suggested to me that the president believes this is likely someone in national security or in the Justice Department. And Rena, you saw that graphic that you put up. There is one agency that is conspicuously absent, and that is the Justice Department, which is constantly the target of the president's ire. I reached out to them earlier today. It is not clear whether or not they will issue any sort of response as other cabinet officials and other agencies have done. But that is one theory, working theory within the White House.
Hey, speaking of DOJ, I want to ask you a question about the DOJ. I know you've covered this extensively. quickly. They just announced charges against a North Korean programmer. This is in connection to multiple cyber attacks, partially including the 2014 Sony attack. What can you tell us about this, Paula?
That's right. Today, the Justice Department unsealed charges against a North Korean hacker, someone who was working on behalf of the North Korean government, and they charged him in numerous cyber attacks. The most high profile was, of course, the 2014 attack on Sony Pictures Entertainment. But he was also charged for creating the malware used in a 2017 ransomware attack, as well as a 2016 theft of $81 million from a Bangladesh. From the Bank of Bangladesh. Now, this is not the first time that the Justice Department has filed charges against someone hacking on behalf of an adversarial nation. They've done this with Russia, with China, with Iran, and now North Korea. But, Rena, one of the complications with taking this approach is that we don't have an extradition treaty with any of those countries. So usually what happens is these charges are announced to great fanfare, but no one is ever actually arrested, nor do they ever see the inside of a U.S. courtroom. So some folks have questioned whether or not this really has any sort of deterrent impact.
Yeah, I get the deterrent aspect. I'm just curious, Paul, when the DOJ makes this sort of decision to announce charges like this, is it in coordination with the White House? Because it's slightly strange yesterday. It comes on the same day the president tweeted his thanks to North Korean leader Kim Jong-un. So why would you thank somebody when you know you're going to press charges against him?
That's right. It does not seem that the Justice Department and the White House are completely on the same page here. Usually when there's any sort of national security case from the Justice Department, there is coordination with the White House, with the National Security Council, with their components here. We are asked at a briefing earlier today whether or not there was any sort of interagency coordination on this. And they said, yes, there was some, but they would not specify who they spoke with, what kind of coordination there was, and whether the president was notified. It is also notable that these charges were actually originally filed back in May. They were just made public today. And of course, when these were originally filed, this would have been around the same time as the North Korean summit between President Trump and Kim Jong-un. So there were some questions about whether or not these were withheld so as not to complicate that summit any further and why they were released today. But the Justice Department was not able to give us any answers about why these charges were made public today.
You know, Paula, I got a fortune cookie on Saturday that said, "May you live in interesting times." I guess that fortune applies to all of us.
I think it absolutely does, and it probably will for the foreseeable future.
Absolutely. All right, Paula, thank you so much. Lots of twists and turns. Paula Reed coming to us from the White House. Well, President Trump's second Supreme Court nominee is back on Capitol Hill for his third day. Thursday's confirmation hearing grew contentious earlier. Did you see this? It was New Jersey Senator, Democrat Cory Booker. He released a batch of documents that were marked committee confidential, meaning that they were meant only for the eyes of the Senate Judiciary Committee, no one else. And as Booker even acknowledged himself, his actions could actually get him kicked out of the Senate.
So I am right now, before your process is finished, I'm going to release the email about racial profiling, and I understand that the penalty comes with potential ousting from the Senate. And if Senator Cornyn believes that I violated Senate rules, I openly invite and accept the consequences of my team releasing that email right now. And I'm releasing it to expose that, number one, the emails that are being withheld from the public have nothing to do with national security. Nothing to jeopardize the sanctity of those ideals that I hold dear. Instead, what I'm releasing this document right now to show, sir, is that we have a process here for a person, the highest office in the land, for a lifetime appointment. We're rushing through this before me and my colleagues can even read and digest the information.
Running for president is no excuse for violating the rules of the Senate or of the confidentiality of the documents that we are privy to. This is no different from the senator deciding to release classified information that is deemed classified by the executive branch because you happen to disagree with the classification decision.
Well, shortly after that, Hawaii Democrat Mazie Hirono also released committee confidential documents, too. And she says that the documents show Kavanaugh believes that programs for Native Hawaiians are constitutionally questionable. For more on the hearings, I want to bring in Scott Wong. He's a senior reporter for The Hill. So, Scott, what exactly was in those documents that Senator Booker released?
Well, there were several documents. I think the one that he was referring to in your clip had to do with discussions in the White House that were taking place right after 9/11 in 2002. There was some discussion about how certain law enforcement programs should be developed, how TSA should handle security measures for airports, in the TSA agency that was being developed at that time. And so these were arguments, discussions that were taking place in the White House. Cory Booker believes that it revealed or showed some of Kavanaugh's discrimination against Muslims, perhaps, but Kavanaugh is denying that. And it's very interesting now. We are seeing senators sort of racing to release documents in the Kavanaugh hearings.
But, Scott, the punishment here for releasing these committee confidential documents could be as serious as actually being kicked out of the Senate. How likely do you think that's going to happen, especially with Booker and Hirono releasing these documents?
I think it's very unlikely that Republican colleagues would move to expel a member of the Senate. In this case, it is sort of unprecedented that we would see Democrats, competing with one another to release these documents that the White House has deemed confidential. However, in the comments of Dick Durbin, one of the Democratic leaders who also serves on Judiciary, he said that he stands with Cory Booker. He associates himself with Cory Booker's actions, and that if you're going to move to retaliate against Cory Booker, then you'll have to move against almost all Democrats, and Republicans, I think, are unwilling to do so.
I want to also ask you about another exchange. This one was from last night, and it was between California Democrat Kamala Harris and, of course, Brett Kavanaugh.
Have you discussed Mueller or his investigation with anyone at Kasowitz, Benson, and Torres, the law firm founded by Mark Kasowitz, President Trump's personal lawyer? Be sure about your answer, sir.
Well, I'm not remembering, but if you have something you want to...
Are you certain you've not had a conversation with anyone at that law firm? Who'd you talk to?
I don't think I'm not remembering, but I'm happy to be refreshed, or if you want to tell me who you're thinking of.
Are you saying that with all that you remember, you have an impeccable memory? You've been speaking for almost 8 hours, I think more, with this committee about all sorts of things you remember. Yeah. How can you not remember whether or not you had a conversation about Robert Mueller or his investigation with anyone at that law firm? This investigation has only been going on for so long, sir. So
right,
please
I'm not
answer
sure.
the question.
I'm just trying to think. Do I know anyone who works at that firm? I might know. I would like to know the person you're thinking of, because what if there's?
I think you're thinking of someone and you don't want to tell us.
All right. Well, that exchange was actually interrupted later by Republican Mike Lee. What do you think this says? What do you think this means? Her pushing for this. This is actually Trump's lawyer's law firm. Why do you think that he sort of painstakingly avoided that question?
Well, I think these are questions that could come before the Supreme Court in future months, especially once we know the results of the Robert Mueller investigation, specifically whether Trump can intervene and stop the Mueller investigation, whether he can fire Robert Mueller himself or members of his team. And so if Kavanaugh is serving on a Supreme Court that is deciding those types of issues, I think it's important, whether we know whether he has had conversations with some of Trump's attorneys who are specifically brought on to deal with the Russia investigation.
And, Kavanaugh at this point, Scott, is there anything that would indicate to you that his nomination chances of being confirmed are actually heard at this point?
I don't think so. We saw the swearing in of former Arizona Senator John Kyle yesterday, who replaced John McCain in the Senate. They are back at 51 seats. It is a narrow majority, but